this Wednesday morning, March 19th. And we're going to turn back to H193 with an additional witness. And Amy, if you could join us. Thank you for being here.
Thank you for inviting me. For the record, my name is Amy Rose. I am the policy director with Voices for Vermont's Children. Typically, when I testify, I have pre-prepared remarks, and I do have some notes here, but I wanted to be most responsive to where you are in the process. And I was able to listen to your previous testimony and hear the questions that were asked before. So I kind of structured my testimony around those questions. Just want to offer the opportunity to interrupt me as well, or ask different questions, or kind of move in different direction. I think the first question that often comes up with this bill is, why is it needed?
I was going to ask that question.
So I was going to start with that. We have an opportunity to bring additional funding to our state and to work collaboratively to ensure that we are taking every opportunity that is offered to us from the federal government. We know that representation matters. We know this, and we believe, and I believe that it is something that all of the witnesses that have testified so far have agreed on. I'm not surprised that some of the witnesses you have heard from have different opinions about how the system is currently working. That is not unique to the Vermont court system. Advocates, much like legislators, hear from folks who are frustrated with their current structures frequently. Sometimes those folks don't feel comfortable bringing their concerns to the people who have power over them and their lives. When people are accessing legal support, when they are engaged in the TIN process, they are vulnerable, they are sometimes angry, and they are at a crisis point. This makes it difficult to navigate our complex structures, and even when the systems are designed well, mistakes can happen. Creating the opportunity to bring us all together will help us get a better understanding of the current structure, the possibilities ahead, and the lessons we can learn from people who have navigated the TINS process. You have also heard in testimony that DCF is ultimately responsible for drawing down Title IV funds, which further illustrates the need for collaboration. The question came up, is more broad TINS reform needed? Voices agrees with the Defender General's comments that we would benefit from a review of the entire TINS structure. H220 is an attempt to do that work. However, I don't see these efforts as either or proposals. This bill is an important and manageable step towards the bigger work ahead. I also believe that we have a lot to learn from our TINS representation structure. I will speak to that more later, but in TINS cases, children have the benefit of both expressed representation through their attorney and best interest representation through their guardian ad litem. The other question I heard quite frequently is, why are there so many TPRs in Vermont? And that is a complicated question, and it will take a while for me to get through it all of my perspective, but I can share just a little bit. The Family Services Division of DCF is not a system that was designed to respond to harm. Not responding is the easiest way to bring our numbers down, but that would not necessarily result in increased child well-being, although in some cases it might. Family Services Division's response is triggered by a report, which often comes from a mandated reporter. Our mandated reporting structure would also benefit from a multidisciplinary review process. Long before the Families First Prevention and Services Act of 2018, we created a differential response system in Vermont. Differential response allows Child Protective Services to respond to reports of child abuse and neglect with either a family assessment or a traditional investigation, depending on the specific circumstances and risk level of the case. This was intended to give families access to support, prevent harm, and to create less of a need for the traditional foster care system. Voices celebrated the shift, but the state failed to fully invest in the community supports that are required to support children and families within our family units. We know that persistent poverty is harmful to kids, yet today, we fund Reach Up by taking a 2001 cost of housing figure, a 2019 basic needs figure to create the DCF basic needs budget, which is about half of JFO's basic needs budget. Then we cut that budget in half with what we call the rateable reduction. We know that a family of 4 cannot meet all of their basic needs, including housing, for under $1,000 a month. but that is the level we are funding them at. Experiencing extreme poverty is stressful. We know that parenting is stressful. When people living in public spaces at their worst parenting moments are witnessed, and they also lack access to transportation, they're missing appointments, their kids aren't making to school, people call DCF. The kids are not well. When DCF does not have the resources to meet their basic needs, and they see that these kids aren't doing well, they're left with impossible choices. Our Family Service Division is our system of last resort. How many kids are unified to an unsheltered caregiver? I don't know, but I'm guessing not many. Vermont is not alone in this. We know that interventions are expensive. It is not a good budgeting solution to rely so heavily on the system of last resort. We know the question of compensation comes up a lot around this bill. Voices is happy to be included in this working group, and just like the other nonprofits or folks who are listed in this bill outside of impacted folks and legislators, we would consider this within our Go Workday structure. We have never received compensation for working groups and wouldn't expect that to change. We do support compensating impacted people, and we do support compensating legislators for work outside of the typical session. The other question that's come up quite a bit is how big should this working group be? I think the bill, as it currently stands with the additions that were brought in by Ledge Council, is a good balance. It includes multiple perspectives, and the group is still small enough for robust participation. You might consider ensuring that a GAL is included. They might already be involved through one of the or designee categories, but if they're not, I think they would add quite a bit to the conversation. I also think Vermont Legal Aid would be a valuable perspective and would include representation from the Victims' Rights Project. I also just want to appreciate including children's advocates in general. I think that there is different training needs when working with kids at different developmental stages, and that is different than folks who typically only work with adults. And this is true for GALs, for judges, for social workers too, not just for attorneys. The next question I keep hearing is why are legislators included? I feel like that's been a big piece of the conversation. I have been involved in working groups with and without legislators, and ultimately it is obviously your call. I find it really helpful to have legislators hear the process, and as well as often the end result that people are hoping for is legislation that people can take action on. And as you know, legislators are the root for creating legislation, and so having them involved can help create the pathway for that. There are also questions about federal funding cuts, right? We're talking about Title IV funds, and there's a lot of uncertainty and unknowns around our federal funding structure. We can imagine that federal funding cuts will be coming. It is unclear sort of how much and where they will be directed. I do want to sort of pause and just remind folks that the Family First Services and Prevention Act, which kind of created this whole process, did pass under the first Trump administration. And I think child welfare in general is a fairly nonpartisan issue. And so I think it's wise to take advantage of all the federal funds that are available right now as we're talking about sort of the shrinking pool. And I also think this is a bit more than a conversation about funding. It's about how our structures are working and coming together to make sure that all of the perspectives are getting to sort of the full group of folks involved. I do have some suggestions for some further changes. As mentioned earlier, we have the opportunity to offer legal and other services in the state earlier than we have before under Title IV funding due to the broad definition of candidates for foster care. So this funding is allowable for folks who are currently in the CHINS network, which is where most of this bill is focused, but it's also eligible, folks who are at risk of child welfare involvement are also eligible for Title IV funds in some scenarios. Voices has spent a great deal of time trying to understand the process for supporting children when there is one caregiver who has caused harm and another caregiver who could parent the child independently. It does not make sense to remove a child from the custody of both parents when there is a parent who is considered safe and capable. DCF can offer voluntary services in these cases, but decisions about custody and visitation in these scenarios typically happen within the domestic docket of the family court. Unlike Chin's cases, children are not parties to these cases and are not automatically assigned a GAL or an attorney. The court does not have the same resources to monitor and evaluate safety over time, or the same tools for supervised visitation at its disposal as it does for the Chin's docket. This is a gap in our current structure. Similar to broad Chin's reform, this is a big topic that will not be resolved in a timeframe that is set out for this work group. It could be helpful to add just RFAs on behalf of minors to this areas of consideration under this working group. One could argue that these kids are at risk of foster care, and it would be helpful to get a better understanding of how representation might benefit these children as safety decisions are being made on their behalf. The RFA process is typically an urgent request. The stage of the process is similar to when DCF files an emergency custody order. It is my understanding that hearsay laws are not a factor until merits hearings when DCF makes this request of the court. But when an RFA is filed, hearsay laws do apply. The person who is filing the RFA on behalf of a minor cannot speak unless they personally witness the harm. They are not able to come to court and say that the child said they were hit and that's how they got that bruise. This matters because when an adult asks for an RFA on their own behalf, they typically come to court and share their story as firsthand information. Without the child represented and the child unable to speak, without a full hearing requesting a GAL, an attorney for the child, it is very difficult to get the necessary information before the judge to make an informed decision. The data that we have shows that RFAs on behalf of minors are less likely to be granted than RFAs filed for adults. They are frequently denied and or dismissed because of hearsay rules, and the child is forced to return back to the prior custody arrangement, which often returns them back to the abusive household. And just to share some of those numbers that we received, 3,577 relief from abuse orders were filed in 2023 on behalf of adults. 3,078 of the RFAs were issued. 3,047 of them were temporarily granted, and 1,003 received final approval. 415 relief from abuse orders were filed on behalf of minors. Only 156 of those were temporarily granted, and only 52 received final approval. In addition, when a child lacks due process, they can be ordered to comply with a court order without representation or an opportunity to appeal the decision that was made on their behalf. This problem is far-reaching. We have a detailed structure to support children in state's custody, but a lack of structure when kids try to navigate our structures of support without DCF. Eventually, voices would like to see all young people who are in out-of-state placements or institutional settings have an opportunity to seek legal representation if they feel their rights are being violated as well. From what we've heard, kids placed at residential facilities through DALE, DMH, and AOE often also lack representation.
Can I stop you just for one second on that? Just so I don't lose this question. With respect to the RFAs for minors, Defender General Office doesn't provide or can't provide representation for those individuals. So they're not represented at this point. Is that my understanding from what you're saying?
It's my understanding that if they choose to represent those individuals, they have to first have a hearing to determine that it's in the child's best interest to have representation. And the RFA process is usually pretty quick. And so often it's recommended that they don't delay and go through a full hearing to determine whether or not they're eligible for representation. And so often they're not represented. And often when they come to court, even if they ask to speak on their own behalf, that is denied because many people feel like it would do harm to them to be a part of the process without representation.
So would creating this other entity to do this change that part of it? You would still have to have that hearing, right? I mean, it's not
proposed legislation to shift it for this one scenario out of the working group. I don't know what would come out of it, but I think it would be helpful to have DCF available to share their process, to have the Defender General share their perspective, and have all the parties together to talk about sort of this gap in care for young people,
For the RFAs,
for the RFAs in particular.
figuring how to maybe get to not have to have that initial barrier to get representation.
Yeah, and I think that it could mirror the DCF process a little bit more. But obviously everyone would need to either come to agreement or would need to come before the legislature for legislation to change that.
Okay, thanks.
And I'm almost done. I think for now, it makes sense to begin with the RFAs on behalf of minors. The numbers are small, but the consequences of errors can be significant. And it is a good place to start talking about at risk of DCF involvement.
So, and with respect to the hearsay issue, does our bill H5 get to that? Is that part of, have you looked at H5 and the hearsay rules?
I have looked at it a little bit. I don't know if it fully gets at this, but I can do some more reading and get back to
Yeah,
you.
we may be taking that up
Okay.
sometime sometime before the end of the session, and could have you in on that one as well.
Thank you. Are there any questions?
Yeah, I have an overall fundamental question dealing with it. It seems written as if we already understand that the Defender General's office is not the right place for this, that they're not necessarily. I think that's why we got such vociferous testimony against this bill. It seems to be more prescriptive already, as opposed to, all right, let's get these people together and let's talk about how it's working now, without saying that we already know that we want a separate new entity doing this. Maybe that is where one ends up, but maybe there should be improvements in current processes through the Defender General's office. And that this isn't written that way. It really seems to already have, and maybe there are those other studies, and I did look at the Chin study from, what was it, 2021, and but even that didn't necessarily say we have to completely do this other process. So that's one concern I have, and I think that to actually be able to move this bill this session, I think it needs some adjustment of what we're asking them to do. I want to look at the problem, but the way it's set up right now is it just seems to be saying, well, we already kind of know where we're going with this. At least that's how I read it.
Appreciate that. And I think it is worth taking a step back. I do think that one of the challenges that probably brought this bill, I wasn't a part of the drafting of it, but I think one of the challenges is a frustration of not utilizing this funding source. And
Right.
To be fair, it took a long time for DCF to begin to move in the direction of trying to embrace families first more broadly. And I think any legislation is a compromise. And so there's some pieces that probably the folks who are offering services would see as positive, and there are some things that seem like unnecessary administrative burdens and other challenges, which it takes a while to kind of sort through whether or not it's something that people are excited about, or if it's something that could be challenging. So I'm fully supportive of taking a little bit of a step back and getting more of an assessment of where we are. I do think that whoever ends up on the working group should read some of those reports before we start, so we don't do the same work again. And my hope is at the end of this process, we'll be able to take an actionable step towards a structure that is, from my lens, more supportive of children and youth and families. And that may be like proposing a structural change, but it might just be sort of understanding the structure we have and making some of these tweaks around a process, for example.
Right. Yeah. And that's kind of the bill doesn't read that way at this point. And I think that we need to, if it's going to advance, we need to modify that. And we'll certainly reach out to some folks, and if you have input on that as well. I may have a pre-working group to help me get to the point of having this working group. So I knew you'd love that, Ken.
I did have a chance to listen to the previous testimony, and I think what I heard in it is that many of the different folks approach this very differently. I heard DCF saying that they're responsible for Title IV funds. I heard Attorney General's office saying they have a process that they're starting, right, to try to draw them down. I I understand the frustration at times of like legislating a working group, but I do think the testimony up to date is the evidence of why we might benefit from like a clear structure and a clear design and clear expectations of sort of what is the work product at the end, and what is our best way to kind of solve some of these problems that are before us.
Right. Yeah. So yeah, we'll continue to work on getting this language right, I hope, and we'll look for your input on that as well. But other questions, Brady? I don't always get to do all the questioning. In fact,
He does most of it, trust me.
oh, stop! I do. So no, thank you very much. This is very helpful, and if you do have suggestions on how to structure the language, we'll certainly be very open to hearing that.
Thank you. And I do see that at-risk category as sort of the opportunity in this work in some ways. It's something that we don't currently have a structure for, and a chance for us all to come together and think about that particular gap in our structure.
Okay. All right. Thank you very much for your testimony. I really appreciate that. So that's it for today. I know a very long afternoon supposedly on the floor, so we will adjourn until tomorrow at 9. Don't go off quite yet. So we are looking at S44 tomorrow. I'm planning on Friday after the floor, if for some reason it's a shorter floor, or afternoon to vote on S9 and S3. We're probably going to have an amendment for S9 that actually I'll probably try to fit in looking at the amendment tomorrow morning, so people will have a day with that before we vote on S9. But that we'll vote on those things on Friday. So adjourn.